And this is the Q&A podcast. I'm your host, Peter Slen. Thanks for joining us. Well, who are the honey badgers on the Supreme Court? And how often is Ketanji Brown Jackson in the majority on Supreme Court decisions? Find out in a moment when we talk with SCOTUSblog editor Sarah Isgur about her new book, Last Branch Standing. Sarah Isgur is the editor of SCOTUSblog, which is all about the Supreme Court and its proceedings. She's also authored a new book about the court, Last Branch Standing. In the first of a two-part interview, we review the history of the court and its ideological makeup. And that conversation begins now. Sarah Isgur, in your new book, Last Branch Standing, you write, I get it. You believe the Supreme Court is an extremist right-wing juggernaut that is taking away people's fundamental rights by rolling back anti-discrimination laws and voting rights and is indifferent to the deaths of women denied basic health care. Or maybe you view the court as yet another elitist institution that allows a left-wing president to ignore the law and technicalities, shut down churches but not the border, all while colluding with tech giants to censor their critics. But which is it? So which is it, or neither?
It's neither. We have imputed on the Supreme Court the thing that we're doing in our politics, this idea of a war of all against all. It's not so much that my team is good, it's that your team is really bad. You hate America, you want to destroy my way of life and burn down my villages. And we've been told and believe that the Supreme Court can be seen through that same lens. Well, a Republican appointed 6 of these people, a Democratic president appointed 3 of these people, therefore it must be the same red team versus blue team that we see in the rest of our lives. And the Supreme Court's just different. And if you want to be able to predict the outcome of cases, if you want to be able to understand what's happening at the Supreme Court, you have to actually understand it as a totally different branch of government that is not directly elected by the American people like Congress is. It's not elected by the nation as a whole like the president is through the Electoral College. This is a counter-majorian institution that is supposed to say no to the majority of the American people. That's where its value actually comes from. It is life tenure, which makes it kind of a lagging indicator of our politics and very slow to respond to political changes in the country. That's a feature, not a bug. And so I wrote the book to try to help people pull back the curtains on this last branch standing. You
mentioned the 6-3 split on appointees. Most votes are 6-3 or 5-4. True or false?
Completely false. The most likely outcome of any case at the Supreme Court is that it will be unanimous. That's 42% of the cases. Of the cases last term, let's say, the 6-3 and 5-4 cases that are divided ideologically with all of the 3 liberal justices in dissent, that's 15% of the cases. So if all you think is that this is an ideological court and Trump always wins, you're going to get it wrong 85% of the time. And what's even better, last term, the exact same number, 15% of the cases, were also 6-3 or 5-4, with the 3 liberal justices all in the majority and only conservative justices in dissent. So the exact same number split ideologically if, you think that's a thing. And it's certainly the case that justices have judicial methodologies, that some are conservative judicial methodologies or liberal. But even there, I challenge people to think more deeply about what that means and how conservative and liberal judicial methodologies don't map onto our politics today. And we've seen that most recently in the birthright citizenship case, where in fact it was this administration that adopted the liberal methodologies, arguing that we should just look at the problems as they exist today and try to solve those problems the best we can with the tools we have. And it was the liberal side that was arguing with a conservative methodology, saying, no, we need to look at what the 14th Amendment's text says and what people at the time thought they were adopting and how that has been liquidated for the last 150 years. So liberal and conservative in law world doesn't even map onto our politics the way that we think now liberal and conservative kind of maps onto Republican and Democrat. I would challenge whether they even work on that side either.
Well, some of the big cases, though, Obergefell on gay marriage and Dobbs on abortion, those tend to fall into the 5-4-6-3 categories, don't they?
They absolutely do. As I said, 15% of the cases out of roughly 60 a year are ideological. They are along that narrative. So it's not to say that they don't have ideologies or that cases don't turn out that way. What I think I push back on is this idea that all of the big cases are along these ideological lines, when in fact we tend to define the big cases after we see whether they come out along ideological lines. So if you look at last term, there was a case on gun manufacturer liability. The country of Mexico sued Smith & Wesson over gun deaths that had been caused by illegally trafficked weapons over the southern border into Mexico. If that case had been 6-3 along ideological lines, I argue that it would be the Citizens United of gun violence. It would be brought up every time there was a mass shooting in the United States. The conservative justices on the court prevented gun manufacturers from being held liable for the deaths at their hands. But instead, you didn't hear about that case. Why? It was unanimous, and the decision was written by Justice Sotomayor. So the gun manufacturers were still held to not be liable, but because it was unanimous, it wasn't big anymore, because it wasn't controversial and it didn't fit that narrative in our political fights that we're having right now. So it's not to say that none of the cases are ideological. Of course there are some, but it's to say that we need to start thinking of the Supreme Court differently, the cases differently, and stop waiting to see which cases are 6-3 and then saying, aha, see, that's a big case. But when it's unanimous, mind you, the lower courts had all disagreed on this question, very smart judges across the country. But when it's unanimous at the Supreme Court, well, that just means it was easy and it's not a big case anymore.
You note in your book that the Constitution has 4,543 words, but it doesn't give, quote, a lot of guidance.
No, there's some areas where it does. How old you need to be to run for president or Senate, that one's very clear. It's, for instance, totally silent, though, on how we're supposed to read the Constitution. Are we supposed to read it as a contract that was signed between the government and the people who ratified it? And if you want to change that contract, you've got to amend the contract through our amendment process. That would be something much closer to textualism or originalism as a way of reading the Constitution. But we have stuff from some of the founders that are like, no. Jefferson, right? He wanted to redo the government every 20 years, every generation. So he didn't believe in originalism and textualism as a way of reading the Constitution. So perhaps we want to think of it as an evolving document that changes with time as our society, as our technology changes, and that we have 9 Supreme Court justices who we hopefully pick for being wise, thoughtful people who can just tell us what sort of the right answer should be. President Lyndon Baines Johnson famously was speaking at Justice Douglas's, actually it was just his 25 years on the bench party that he threw. And President Johnson said, it takes 2/3 of the Congress and 3/4 of the states to amend the Constitution, but Justice Douglas can do it in an afternoon. He meant that as a compliment. I think a lot of people would think, oh no, that's not the way this is supposed to work, and is part of the reason that I think Congress is doing so much less these days, is because we, the American people, don't want to go through the hassle of amending the Constitution and the compromise and the sort of going state to state process that requires. Instead, we want to fight over who the Supreme Court is going to be and then expect them to amend it for us. And now we're seeing that happen at Congress, where most of the fights we're having, the headline may say, Supreme Court strikes down Biden's student loan debt forgiveness. Supreme Court strikes down Trump's tariffs. We have 2 cases pending this term on whether Mississippi can accept ballots 5 days after the election, or whether Donald Trump can turn people away who want to apply for asylum at the southern border. Culture war cases across the front, right? All of those are simply acts of Congress. Congress tomorrow could ban partisan gerrymandering, decide whether Mississippi can accept those ballots, make rules for asylum at the southern border, do or don't do student loan debt forgiveness or tariffs. But we don't believe they'll do that. So instead, we start thinking of the Supreme Court as the last word, instead of part of an ongoing dialogue with Congress and with us, the people who can actually amend the Constitution.
You write that the Supreme Court decides questions, not cases. What does that mean?
Again, I think so often we read these stories about the Supreme Court and we think the Supreme Court is saying whether X policy, student loan debt forgiveness or tariffs, fill in your favorite one, are good policy. When in fact, the only thing the Supreme Court is ever charged with answering is who gets to decide this question. Is it a supermajority through the amendment process? Is it only through Congress? I use the example in the book of the fight we're having over library books in our public libraries. Okay, your public library cannot take all of the books in the world that have ever been written. So, who gets to decide which books are in there? Is it the librarian? Is it the people who go to the library? Is it the city council? Is it the governor of the state? Is it Congress? That's all our courts get to decide, is which level of democracy, of representative government that we've agreed to in a pluralistic society, does this question get decided on? It's never, this is good, this is bad type of work at the Supreme Court.
Let's remind our viewers who's on the Supreme Court. Let's begin with the Chief, John Roberts. George W. Bush appointed him. It was in 2005 that he got confirmed. Clarence Thomas is the longest serving. That was a George H.W. Bush appointee, 1991. Samuel Alito, George W. Bush, 2006. Sonia Sotomayor, she was an Obama appointee in 2009. Elena Kagan as well in 2010. Neil Gorsuch was the first of the 3 Trump appointees. 2017, Brett Kavanaugh, 2018, Amy Coney Barrett, 2020. The newest member is Ketanji Brown Jackson. She is a Biden appointee, and you write that she is in the majority of Supreme Court decisions 51% of the time. That may surprise some people.
I would think so. Again, when you have 42% of the cases that are unanimous, every justice
That's the baseline. That's where you start, right?
Is going to be in the majority a majority of the time, even a justice who dissents as often as Justice Jackson does.
The full name of the book is Last Branch Standing, a potentially surprising, occasionally witty journey inside today's Supreme Court. Where did the title and the idea for this come from?
Well, like all good things, we were up against a deadline, and my husband and I got out a bottle of wine to try to come up with the right title, and our kids had gone to sleep, and we're sort of talking about the thesis of the book. And this idea of Congress not doing its job, of presidents now running the country by executive order. And one of us said something like, boy, this would be the only branch the founders actually recognize. It's the last branch standing. And we were like, got it. So nothing some white wine can't fix is the answer.
What's your day job?
My day job, I am the editor of SCOTUSblog and host of the Advisory Opinions podcast with New York Times columnist David French and an ABC legal analyst.
And what is SCOTUSblog?
Oh, SCOTUSblog. This is the place to get the nerdiest coverage of the Supreme Court. We have the stat pack where you can get all the numbers that I'm talking about here for each term. But we also cover every oral argument, every decision that comes out. And you will get a really, I think, accessible but detailed description of what the Supreme Court actually decided in all of these cases, how oral arguments went. But we also have lots of columnists, some range from hilariously fun, like John Elwood, on which cases are getting relisted. I know it doesn't sound sexy, but he makes it super fun. All the way to some of your favorite law professors in the country having an interim docket blog where they talk just about what we call the shadow docket or the emergency docket. Every time there's a new development on there, they just go back and forth.
Harvard Law.
Yes.
Did you ever practice law?
Boy, it kind of depends on how you define that. I have a license to practice law. So am I practicing law? I worked on several presidential campaigns.
Carly Fiorina,
Yep.
Mitt Romney.
Yep, both Romneys, 08 and 12. And so, depending, I could sign my name, Esquire.
You clerked for Judge Edith Jones, kind of an also-ran when it came to the Supreme Court, isn't she?
Yes, she is there with David Souter in the Oval Office. where one of them gets shown to the Rose Garden and she is shown out the back door in this like very literal apprentice style thing back in the early 90s. I clerked for her after that, obviously, but there's a saying on the Fifth Circuit, Judge Edith Jones, you know, she's tough, but she's tough.
Sarah Isgur, you have a theory in this book, the X and Y axis theory. Could you explain that? You made me do math in reading this book.
I went into college as a math major, so apologies, but I speak in the language of math, I think in math. So, you know, if you take out your graph paper and we draw an x-axis at the bottom, that is your ideological axis. And it's going to graph about how I think your viewers are going to think about it, right? The Republican appointees are all going to be on the conservative side of that axis, and the Democratic appointees will be on the liberal side of that axis, you know, maybe varying a bit, but roughly speaking.
So simply speaking, X equals ideology.
Yes.
Okay.
Importantly, Brett Kavanaugh and Neil Gorsuch are going to be on top of each other on this axis, right? They are remarkably similar creatures, and I hope we'll get to the lack of diversity on the Supreme Court at some point, but they are the sons of powerful DC mothers. Before that was, you know, a thing. There wasn't a women's restroom in the Senate when Neil Gorsuch's mother was running the EPA. They go to the same high school. They have the same history teacher who is still teaching, by the way, so who only knows how many more Supreme Court justices he has in the pipeline that we haven't met yet. Mr. Oaks, shout out. They clerk at the Supreme Court the same term for the same justice. They both work in the George W. Bush administration, where they are appointed to the circuit courts, and then they're both put on the Supreme Court by the same president. They are, you know, Federalist Society Petri dish lab creations with excellent hair. So right next to each other on that x-axis, and we'll get back to that in a second. Okay, y-axis. This is your vertical axis. This is something I call more like institutionalism. What do you think about precedent? Do you believe that this is sort of one Supreme Court over 230 years? You know, there's only been 117 of these folks, roughly speaking, on the Supreme Court. So they could all fit into a room together. Are they in one project over time? Or is your job just to say what you think the facts applied to the law are in this case, and doesn't matter what that dude over there who's long dead thought? You can only say what you think now. What are the consequences of a case? How much are you willing to not take a case right now, or narrow the question in the case? Maybe take out that paragraph because you can get someone else to join your opinion. Those are all things that you would consider on that y-axis.
Y equals institutionalism, is that fair?
Yes.
X equals ideology, Y equals institutionalism. We will be coming back to that throughout this interview. Another theory you have is the breakdown, 3-3-3.
Yes. So let's get back to Justices Gorsuch and Kavanaugh, right? They're sitting right next to each other on the x-axis, but they are about as far apart as you can get on the y-axis.
Who's at the top?
Justice Kavanaugh is our high institutionalist. He is the team captain. And if you think about it, this makes sense, right? He likes baseball and basketball. Those are team sports.
He's a coach.
He's a coach. Justice Gorsuch, he's into biking, very into skiing. Those are solo sports.
Libertarian.
Very libertarian guy. So he is a low institutionalist. And last term, these two guys who are right next to each other ideologically only agreed with each other 50% of the time in those closely divided cases. Justice Kavanaugh was more likely to be on the same side as Justice Kagan and Justice Sotomayor, even though they are far apart ideologically. Justice Gorsuch, much more like Justice Jackson. They could not be further apart ideologically, but they're joining each other's concurrences all the time because they see their view of what it means to be a Supreme Court justice much more similarly as, I call Justice Gorsuch the YOLO justice. He's just out there, just kneel, right? Like he's just doing his thing. So if you think about these 9 justices as something more like a high school lunchroom, you know, you don't always have to sit with your friends, but like I kind of know where to find you at lunch. You've got your 3 liberal justices, Kagan, Sotomayor, and Jackson. They're sitting together. I call them the lonely liberals. But it's fun to sort of talk about what it means to be influential on the Supreme Court when you're not in the ideological majority, because they still are quite influential. Then we've got our lunch table. This is like our the jocks and cheerleaders table. This is the deciders. A justice once said, you can do anything with 5 votes around here. You need one of these guys to get to 5. This is the Chief, Justice Kavanaugh, and Justice Barrett. Not surprisingly, they're all high institutionalists. And then, of course, the conservative honey badgers. Think of this more like your Dungeons and Dragons table, like they're sitting together, but they're not really talking to each other much. They're kind of doing their own like Magic the Gathering game or something. This is Justices Thomas, Alito, and Gorsuch. So again, you see that Justice Kavanaugh and Gorsuch get appointed by the same president to the Supreme Court with those remarkably similar backgrounds, but they don't sit together at lunch. And I mean that metaphorically, because they do literally sit together at lunch after every oral argument where the justices do have lunch together.
Why the honey badgers?
There's that meme, honey badger don't care. Honey badgers are very solo creatures, ornery at times. That fits.
How does the Supreme Court decide which cases to take?
This is the $60 million question at the Supreme Court that, again, probably determines far more about the direction our country takes legally than the actual decisions that get made at the Supreme Court. There are thousands of cases that are appealed to the Supreme Court. They take only 60 of them, very, very few. It's totally up to them which cases that they take, and that number keeps ticking down. In my lifetime, it would be 150 cases. And yet here we are like at 60 cases. It takes 4 justices to agree to take a case. But of course, there's some strategy involved in that, right? Just because you're the 4th vote, if you don't think you're going to have 5 votes for your view of how you think the case should turn out, you should vote no on taking that case, right? And when you think about this in the context of the narrative we're told about the Supreme Court, if this were a 6-3 solid conservative Trump always gets his way court, there's some things you would expect to see. Well, if it only takes 4 votes to hear a case, and you want those 4 voters to be confident that they have 5 votes for the outcome of the case, they have 6 votes, right? So we should be seeing an uptick in cases every time one side controls the court. We should be seeing an uptick in the number of precedents that get overturned when that changeover happens. And instead, we're seeing the exact opposite. This court is overturning fewer precedents than at any time in modern Supreme Court history, and they're taking fewer cases than at any time in modern Supreme Court history as well, which, again, I think tells you a lot about how these justices view what it means to be a Supreme Court justice. It's not about changing the law to reflect their views of it. It is about answering these questions of who gets to decide, who should decide these. And so they don't view the world in 4-year terms of a president. They outlast presidents every time. This was how John Marshall built the institution of the Supreme Court, by telling Jefferson to jump off a bridge and telling Jackson, defy us at your peril. I'll outlast all of you. They view this very long-term project of building the scaffolding of the rule of law. And so if you look at it that way, the student loan debt forgiveness case and the tariff case are part of the same project, making the president maybe more accountable, a more powerful president, with hiring and firing power over the people who work there, lessening the power of independent agencies to be independent within the executive branch, but making the presidency weaker and forcing the president to actually go to Congress to get laws passed by Congress by saying, no, all of those executive orders are unlawful, and we're striking, in Biden's thing alone, vaccine mandate, eviction moratorium, student loan debt forgiveness. Now, of course, with Trump, Alien Enemies Act, tariffs, birthright citizenship, all of those executive orders falling, not because of who the president is, but because, again, of this longer-term project that they think they're on.
Well, walk us back through the evidence of why that you present of why the Supreme Court has become what it has become because of Congress and the president.
Yes. we can bop into these little moments in history, in American history, and the Supreme Court is always playing a fascinating role. So I don't want to do a march through history, but truly, I think it is important to realize that we don't really have a Supreme Court when George Washington is president. I mean, we literally have a thing called a Supreme Court, and John Jay is the Chief Justice. But John Jay does 4 cases his entire time that George Washington is president. He says that it's beneath his dignity to be Chief Justice because this branch is useless. Why? This makes perfect sense. George Washington is amazing, right? He's perfect. No one's going to disagree with George Washington. You don't need a counter-majoritarian branch for George Washington. You can just leave it to him. So it's not until we have our first partisan election in 1800, this is Jefferson versus Adams, the Democratic Republicans versus the Federalists. The whole country almost falls apart over this election. Jefferson calls Adams a hermaphroditic character. If you think things are bad now, no one's called each other a hermaphrodite recently, so we can keep that, sign on the wall how many days since 1800. So we're good. That's when the Supreme Court comes into existence with Chief Justice John Marshall versus Thomas Jefferson. They are cousins and they hate each other. And it is the best Netflix show I can imagine. I think about it all the time and the different characters that were involved. Jefferson tries to impeach one of the justices, Justice Samuel Chase, who's on the Supreme Court at that point, in the hopes that he can then impeach John Marshall and make the court reflect the partisanship of the president in office. He has a supermajority in the Senate. He can do it if the party stays loyal, but they don't. They vote against Jefferson's wishes, and the Supreme Court is then built as this independent third branch of government. So this is going to become important when we get to the progressive era. And let's be clear, let's underline era. I mean Teddy Roosevelt and Woodrow Wilson. This isn't the progressives that we talk about now. This was the idea at the turn of the last century that, democracy was kind of messy and maybe dumb, and why are we trusting all of these voters who are idiots? Congress is then full of the people who the idiot voters pick, so they're just proxy idiots in Congress. They don't know anything. Well, we need our experts deciding these questions for us. And in many ways, we've been on this 100-year march of removing power from Congress to experts. So the progressives build these independent agencies in the executive branch. They believe in eugenics as a way of experts deciding what the correct people are, what they should think, believe, look like. The worst decision the Supreme Court ever made after Dred Scott and Plessy and Korematsu is a case very few people have heard of, which is a progressive era case called Buck v. Bell. Carrie Buck was raped by her foster parents' nephew, and the state of Virginia forcibly sterilized her because, as Oliver Wendell Holmes, a justice on the court, wrote, 3 generations of imbeciles are enough, right? This was the idea that experts will decide whether Carrie Buck should be able to have children. The evidence that they brought, by the way, was that she had passed notes to boys in elementary school and therefore was a loose woman. The story just gets more and more tragic as you dig into it. The daughter that she had from that rape is given to the foster parents and dies at a very young age. So this is the idea that we don't want to solve our problems through the democratic process, through the negotiation and compromise that's required in Congress. We want to move more quickly, more streamlined, and again, experts get to decide that. So over 100 years, we have just further and further moved questions away from the democratic process and into these questions of experts in the executive branch. Well, at the same time, of course, the Supreme Court gets full control over its docket. It doesn't have to take the cases it doesn't want to hear, starting in 1925. And we see the Supreme Court become a more powerful arbiter because Congress is no longer doing the job that it was doing. The Supreme Court starts to step in to now be the referee between the president and Congress, and this idea of when the president can act alone. And you kind of see this come into its full blossoming at the beginning of the second term of the Obama administration. Obama's immigration reform fails in Congress. Republicans in Congress block it. And he says, I have a pen and a phone to sign executive orders and a phone to rally the American people to my cause. And he has a year of executive action where he does 88 executive orders, which sounds so quaint by our standards today, but at the time was quite a bombshell change, because if you're a member of Congress, let's imagine you're a Democrat at this point, they were working on all these compromises with Republicans to try to get immigration reform across the line. But the president just did DACA and DAPA all by himself when the negotiations failed. Why would we ever compromise again? Then someone can primary me and say that I gave up X, Y, or Z to reach that compromise, but the president could give us everything we want from our side. And if you're a Republican, you think, this is how we're going to run against him next time. This is how we're going to win the office. And you see the creation of negative polarization that we live in today, starting from this moment. And I just want to be clear that this isn't a partisan point, because the second Donald Trump comes into office, he's like, hold my beer. We are only doing executive actions. We're never working with Democrats again. What a silly idea. And the idea of legislation really dies on the vine at that point. Government by executive order takes over. And the members start to see that they have more to fear from primary elections than they do from general elections, so compromise becomes a bad word. And the difference between the guy who spent all of his time raising money on Instagram through anger and outrage at whoever the other team is, and the guy who spent 6 months working on a piece of legislation that never saw a vote, the guy on Instagram raised all the money and he wins in the primary. And the person who's actually doing the legislation fails. And you then have the activists who are thrilled when they're invited to the Rose Garden for whatever executive action the president signs. The headlines and the press releases, you got everything you wanted, yay. Congress doesn't have to face a primary, and maybe the Supreme Court in a few years will strike it down. But don't forget, the headline will read, Supreme Court strikes down Biden's student loan debt forgiveness. It won't say, Supreme Court says, what the hell was Biden thinking not going to Congress to get this passed? Blame them. The activists will blame the Supreme Court, not President Biden, not Congress. And if it's climate change or immigration or whatever issue you think is most important in solving right now for this country, it doesn't get solved. We have executive actions that stay in effect for a couple years. You don't solve climate change in 4-year increments. You have to solve it in a pluralistic society with the stability and long-termedness of doing legislation in Congress.
So we got executive orders on one hand and fear to legislate by Congress on the other hand?
Yeah, I think that's right.
What does that mean to the Supreme Court then?
Well, it puts them in the middle of all of these partisan fights because voters don't believe and don't hold accountable Congress. You see these polls that say, do you believe that Congress should, compromise more to pass legislation? 85%, yes. Would you be willing to have your congressman compromise on the issue that's most important to you? 85%. Heck no, I'd throw him out of office. Those are incompatible ideas. And so if we no longer believe that Congress will legislate, and if we keep cheering on presidents who act through executive action, it's left to the Supreme Court to then man the stations of separation of powers, because otherwise, again, there's no problem that can be solved in 4-year increments. Even if the Supreme Court says the president has the power to do that thing, the next president who comes into office repeals it the first day in office. They have no staying power. And because they're so extreme, right? An executive action doesn't need anyone else's opinions. It doesn't have to say, oh, that's a good point. That probably won't work, actually, in my district. We need to have a different rule for a rural versus urban place or whatever else. It's just like some people sitting in a room who all think the same way about a problem. They tend not to be very good solutions either. So they don't last. They're not very good. They tend to be hyper-partisan. And so they further polarize the country. And so it makes us believe that the next election is the most important election of our lifetime, when in fact, it should actually be for your member of Congress, because it should be about the policies that they are passing, not about who the president with the pen and the phone is.
So, Sarah Isgur, we learned that the Supreme Court, it takes 4 votes to get a case in front of the Supreme Court. Can anyone in the United States petition the Supreme Court for a hearing?
Yes, but there are paid petitions where you have to pay a filing fee in order to apply for the Supreme Court to hear your case. There are unpaid petitions.
What do those cost?
Well, interestingly, the filing fee isn't that much, a few $100s. It's the printing fee that'll kill you. It costs thousands of dollars to print the briefs. They all have to be the right color. Different briefs have a different, it's like light green, dark green, certain orange, this cream color. No, this is a tan color. There's like dozens of colors for different types of Supreme Court briefs, and they have to be printed with certain fonts, certain sizes, certain binding. There's only a few printers in the country that can do it, and that will run you in the thousands of dollars.
And do you have to print 9 copies? One for each justice?
Far more than 9, because each of the clerks need one too. So dozens of copies, plus for the archives.
Why does the Supreme Court session begin October 1st and end June?
So it actually runs October 1st to October 1st. It's not October 1st, it's the first Monday in October, but to use October 1st as our stand-in for that. So the term is a year long. So it's up to the justices to decide when their merits docket is done for the year. They tend to do that on the last day of June. As one justice said, I can do the work of the Supreme Court in 11 months, but I cannot do it in 12, meaning I need a break from this place. Now, of course, the reason that that started is because of malaria in the swamp in DC. They literally had to get out of town in the summer so as to avoid disease.
Is that constitutional that it begins on the first Monday in October?
It is not in the Constitution, but it is in statute that it will be the first Monday in October. And of course, there is a Mass the Sunday before that is called the Red Mass. For those who are West Wing nerds out there, there is a whole episode called Red Mass in the West Wing show.
Why are some of the major, more contentious cases decided or handed down in June, May, late in the year?
So this is going to be one of those times where I'm like, I know it feels that way, because it is. You're exactly right. What you will hear from the justices and from the clerks is the cases take the amount of time that they take. So the more contentious that they are, the more that there are separate opinions, the longer it takes to write them. Because once a majority opinion is circulated, that's when you then might start working on your dissent to answer what the majority said. A concurrence pops up. Well, you know what? We talked about this in conference, but you didn't really answer my concern, so I'm going to write separately. And at this moment with this court, we have more concurrences, meaning separate writings from justices who are in the majority than ever before in the United States history. Back in the 1950s, we had like fewer than 1 per case. Now we are at more than 3 separate opinions per case on average.
Who's the champ in the current court?
That would be Justice Neil Gorsuch. He is the great concurrer of this Supreme Court. Again, it goes to what you think of your role. Is your role to answer as a single court, a middle school group project where you turn in one diorama and all 9 of you need to contribute to it? Or is it to say what you think about the law, in which case, yeah, you're going to want to write separately a lot because your view is going to be slightly different than even someone who agrees with you on the outcome. And we saw this in the tariff case. What a great example. You know, the tariff decision is argued at the beginning of November. We don't get a decision until February. The majority opinion was only 25 pages long. But we had another 100 or so pages of opinions from the other justices, including a lot of pages from Justice Gorsuch, concurring, of course, and also Justice Barrett responding to Justice Gorsuch's concurrence, which attacked is too strong a word, which criticized her for her views of the major questions doctrine versus his views of the major questions doctrine. Mind you, they thought the major questions doctrine, when applied to the tariff question, came out the same way. Why were we spending all this time writing these concurrences to have this academic fight about a doctrine that came out the same way this time?
Are you suggesting that justices can slow roll a case?
You will hear from time to time justices accuse one another. Of course, accusing at the Supreme Court is written in the floweriest, happiest language of potentially slow rolling a case. But the Chief Justice, you know, he only gets 1 vote. He doesn't actually get to like tell anyone what to do. He can't make them fire their clerks. He can't really make them do anything, but he gets $10,000 more than an associate justice. He is the chairman of the Smithsonian, so he, as he brags, gets to be the first one to see a new baby panda. Huge. And he also gets to set the deadlines for when a majority opinion must be circulated by. So that's why you get the end of June part, because he sets the deadline that all majority opinions must be circulated. I hope I don't get this wrong off the top of my head. I think it's May 15th internally. And then it takes roughly another 45 days to get all those concurrences and dissents and the footnotes responding to each other worked out. And that's why starting about right now in the term, they will now start releasing opinions at a much faster clip, and why most of the unanimous opinions from this term have probably already come out.
All right, you mentioned it earlier, but what is the emergency docket and why is it growing?
Whew, boy, both of those questions you can have entire debates over, but I will give you my best answer. So the shadow docket, emergency docket, interim docket is what will the law be while this case is pending? So if a president signs an executive order, will that executive order be in effect or not be in effect while we determine whether it was a lawful executive order? In the case of President Trump's birthright citizenship, someone has to decide whether we're going to keep the old definition of birthright citizenship or use his definition of birthright citizenship while this case has finally made its way to the Supreme Court. So it's a very important question. And we have 3 layers in the federal courts. We have district courts. They are the first level to see these, trial judges. And then we have 3 judge panels at circuit courts around the country. Every region of the country gets their own circuit court.
13 circuits?
Yes, there are 11 that are numbered. So the 5th Circuit broke off into 2 and made the 11th Circuit its little baby. They would be mad at me for saying that. And then you have the DC Circuit and the Federal Circuit. So that's how you get to 13. And then you have the Supreme Court that sits above those. So Donald Trump signs his birthright citizenship executive order. A district court looks at that and says, I don't think that's going to be lawful, so we're not going to have it in effect while I decide for sure whether that's going to be lawful. While the government can then immediately appeal just that question to a circuit, a 3-judge circuit panel. And maybe they're like, I don't know, let's let it go into effect. YOLO. They can then, the other side, the losing side, can now appeal that just again, whether it will be in effect through the course of the litigation to the Supreme Court. And that's what we call the interim docket at the Supreme Court, when there is an application for what the status quo will be.
Is the government, the federal government, a party in all Supreme Court cases?
No. Boy, that's not a statistic I have off the top of my head, but my guess is it's probably a little under 50% that the government would be a party. You've got a lot of big cases that are between 2 corporations deciding something. You've got a ton of cases involving states versus criminal defendants, for instance, that could end up at the Supreme Court on questions of federal rights that are guaranteed to criminal defendants. And you've got, fun disputes just between individuals who happen to nevertheless have federal jurisdiction because they're from different states, or because of the dollar amount, or because there's a federal law at question. So actually, I'm going to revise down. I think that it's well below 50% actually involve the federal government. Maybe I'm more at 30%?
The Dobbs case, the abortion case, that was a Mississippi state government case versus the clinic?
Versus the clinic itself. Yes, the clinic sued the secretary of whatever in Mississippi. And so, yeah, that was a question of state law, whether it violated federal law. In this case, the federal constitution. Mississippi had passed a law saying that abortions would be unlawful if you were past 15 weeks. Well, our Constitution doesn't say anything about abortion like we talked about. There aren't many words in it to begin with, so we wouldn't expect it to. It doesn't use the word privacy at any point. But we have this amendment in the Constitution that was really fought over at the founding. You know, the original Constitution had no Bill of Rights. It was just this, core part that's really about how the government itself functions. It says nothing about like your rights that you retain against the federal government. And so the anti-federalists, the ones who did not want the ratification of this federal constitution, were like, look, we will vote for this, but you'd better guarantee us a Bill of Rights for individuals. And so we do that, but the Federalists were concerned, if we do this Bill of Rights, what about all the rights that we don't think about, that are so obvious, that we happen not to write down? It will actually constrict people's rights. And so there's an amendment to the Constitution in the Bill of Rights that says, basically anything not listed here doesn't mean that you don't have a right to it. We will call that the unenumerated rights problem. We know that there are rights that are not listed, but what are they, and how do we decide them, and who gets to decide what they are? And so this was the question about abortion at the Supreme Court, going all the way back to Roe v. Wade. Is abortion an unenumerated right that is guaranteed to you as a citizen against encroachment from a federal or a state government? The Roe versus Wade court said yes, and they were like, look, if we look at the penumbras and emanations, then, and that's a term that I would not know either of those words, frankly. Maybe emanations. I certainly wouldn't know penumbras. It's this like wafting idea, right? An aura that an amendment gives that nevertheless protect a right to privacy, and a right to privacy then protects a right to abortion. This, of course, is going to set our country off on a path that will define the two political parties. Then a case called Casey in 1992 is going to actually ditch Roe v. Wade. It's like, okay, that was actually very poorly reasoned. We're going to try this again. The right that is protected is a right to an abortion without an undue burden. And then we were off to the races for the next 30 years on like, well, is this a burden? Is that a burden? Is that too much of a burden? So then Dobbs gets decided, again, 6-3 along ideological lines. And the court holds, you know what? This isn't an unenumerated right at all. The founders would not have said that you had a right to abortion at the time of the founding. So if we want to do that, to get back to our who decides question, that will need to either be an amendment that is ratified by the people to protect that right, or it is left to the states to determine that question. So the who decides is the supermajority through the ratification process, or the state governments, which is where we are now.
Who argues the case for the federal government?
The Solicitor General of the United States argues on behalf of the federal government, but there's something a little bit interesting about that. We've only actually had a Solicitor General since the late 1800s, and the Solicitor General works for the president, but they represent the federal government. So who actually represents Congress? Nobody? The Solicitor General? I think there's been a bit of a tension, especially right now as we think about the constitutional crisis not being what it was at the founding, the federal government versus the states, but in fact now really the presidency versus the Congress, that the person who argues for laws that are passed by Congress nevertheless only works for the president.
So is Congress ever a party in a case before the Supreme Court?
Almost never. They would have to have something called standing to be a party before the Supreme Court, which means they would have to have a specific injury. And the Supreme Court so far has basically said, voting for a bill and then the president not enforcing that doesn't give you, a congressman, a specific injury. Same reason we don't have taxpayer standing, like just because you technically a quarter of a cent of your taxpayer dollars went to go fund this thing that you think is unlawful, you don't get to go sue about it. Justice Scalia defined standing as something like, what's it to you? And that we're not going to have roving bands of citizens looking for unlawfulness. It has to actually be a concrete injury so that we can have a real case or controversy, because that's how we make the best decisions, through a true adversarial process, not just that doesn't sound right to me, I don't like it.
Writ of cert. And I'm not going to pronounce the whole word. I'm going to certiorari.
There we go. You nailed it.
Is that one of the way to pronounce it?
Yes. So all 9 justices have slight variations on how to pronounce this word. Interestingly, Justices Barrett, Gorsuch, and Kavanaugh almost never will say it. In fact, I could not find a time where they have actually said it in court at an oral argument, they will say, grant review or cert.
And what does it mean? What does it mean, writ of cert?
This is the 4 votes, right? This is where you vote to decide which cases to take. Will they issue a writ of certiorari or certiorari, or the actual correct Latin pronunciation, I am told by Latin professors, is certiorari, which nobody in the history of lawyers has ever used in their life. But it is where you actually send down an order to the lower courts to ask for the record from the case. So it actually is a real writ. Writs do a thing.
There's another term that Supreme Court justices often use. Let's listen.
Under principles of stare decisis.
Stare decisis.
Stare decisis.
Stare decisis.
Principles of stare decisis.
Stare decisis.
Stare decisis.
I talked about the doctrine of stare decisis.
Sarah Isgur, what are we talking about?
Well, first of all, notice they all pronounce that the same. That we've got down. These Latin terms, we butcher them in law world, but we do try to be consistent, except for the cert problem. By the way, how young did the Chief Justice look there? I had such a crush on him in 2005. Please don't tell him. So stare decisis is Latin for to let the thing stand. This is the idea of precedent. And I do think that there's a misunderstanding about precedent. Precedent isn't just the idea that a current court should uphold what a previous court said because, I don't know, Yahtzee. It is about upholding what a previous court got wrong because stability in the law is more important than getting the law right. And so when someone says, it's important for the court to uphold precedent, it's important to press that person on, tell me a case where you think the court got a question wrong, but you nevertheless think that we should uphold that decision. And so when we talk about the Dobbs decision, for instance, it's really not about precedent unless you think Roe v. Wade was wrongly decided. Otherwise, you just want to have the same outcome as before. That's not a stare decisis question. And Justice Elena Kagan has talked about this, I think, in the most helpful way. She calls stare decisis a doctrine of humility. And I absolutely agree with her because it's the idea that, I sitting here now think that that court got it wrong. But who am I, right? What if I'm the one who's wrong and they're the one who's right? And so it's about stepping back and saying, boy, let's leave this in place a little longer. Let's make sure we think they got it wrong. And so you have justices who view that differently. There was a case called Ramos, which is one of my favorite cases to talk about because it's not a culture war question, but it is a constitutional question. Can a state use non-unanimous jury verdicts to convict someone of a serious felony? As in, do you need all 12 people to agree that you were guilty beyond a reasonable doubt? Or is 9 enough? And in 2 states, they still said that 9 was enough. Washington State and I believe Louisiana, but sorry if I'm wrong about that, Louisiana. So that goes to the Supreme Court. There had been a previous case about this called apodaca. Now that's a fun word to say, not Latin, highly recommend. All 9 justices at the Ramos court, so our current court, believed that apodaca was wrongly decided. So the only question that they disagreed on, and it was a 5-4 decision, apodaca is wrongly decided. Should we let it stand anyway because stability in the law is more important than getting it right? Or should we overturn it because if it's wrong, let's fix the law and say, no, you have to have a unanimous jury verdict. So 5 justices said, yes, unanimous jury verdict. 4 justices said, I think the Constitution does want you to have a unanimous jury verdict, but we should leave it in place because states have grown to rely on it. That's what stare decisis is actually about.
11,000 men and women have served in the House of Representatives in our history. 2,000 men and women have served in the Senate. 116 men and women have served on the Supreme Court. It's a pretty low number.
It's an incredibly low number. They serve for a very long time. I mean, isn't it interesting that Justice Thomas, who has been on the court since the George H.W. Bush administration, is not the longest serving justice in United States history? You think we're living so much longer now. Nope, you have to go back hundreds of years to find the longest serving, and the longest serving Chief Justice is still John Marshall. 1801 to 1835.
Who was the fourth Chief Justice.
Fourth Chief Justice, but he's number one in our hearts.
Today, on the court, 8 of the 9 justices are Ivy League grads. 6 served as clerks. 8 served on the circuit court and were not elected to any office. And only 1, Justice Alito, had a short military career. Now you compare that to what happened in 1954. 1954, Brown versus Board of Education. The court then, 5 of the justices, public universities. 1 didn't even have a law degree. 8 had military service. 5 were elected, and 2 had served as attorneys general. What's happened?
We have, in my view, over-professionalized what it means to aspire even to be a Supreme Court justice. So you mentioned that 6 of the current justices had clerked on the Supreme Court. You know, it's even worse than that. 3 of the current justices clerked for the justice that they replaced. We've created like a hereditary peerage. The chief replaced the chief. Justice Kavanaugh replaced Justice Kennedy, and Justice Jackson replaced Justice Breyer. I mean, my God, and when you think about what it means to clerk at the Supreme Court, you have to have clerked for multiple circuit judges at this point. Well, what does it mean to be able to take one-year jobs where you're not getting paid nearly as much as your peers at law firms and you're having to move to random places around the country to do it? First of all, you probably have the economic ability to do that. You don't need to, for instance, support your family. You don't have a parent who's sick. You probably don't have a family yet yourself. You probably don't have kids. You probably went to an Ivy League school. To get into an Ivy League school, you probably went to an Ivy adjacent school for undergrad. To do that, you probably went to certain high schools. As we mentioned, 2 of the justices went to the same private high school in the same class with the same history teacher. So in some ways, we've narrowed the path to becoming a Supreme Court justice where, like, at 13 years old, I can tell you, like, sorry, you're never going to become a Supreme Court justice. I think we not only lose something because of that, just on its face, that's not great for America, but we also lose something at the court itself when we don't have a diversity of legal experience. You know, Justice Sandra Day O'Connor had to run in a campaign for state elected office. Justice Anthony Kennedy was a solo practitioner who had to go visit a sausage factory in Mexico so that the employees could keep working. This is the sort of legal experience that I think is important at the Supreme Court, where they're getting every case in the country. And instead, we have people who are on this very, very narrow path. Most of them have worked in the executive branch. Most of them, again, have sort of grabbed all these gold stars along the way. So we're picking from a very narrow pool of people who all know each other, who've all worked together, and who have a very narrow view of what it means to be a Supreme Court justice, what it means to decide who decides. I think we've thought about diversity all wrong. It's not diversity of, religion or national origin or race. Those are important. It's not diversity of ideology, though that's important. I just want some diversity of experience. Let's pick someone who at least didn't clerk for the same justice. But the reason that's happening is it's the way often that you're seeing the White House coax these justices off the bench. Hey, I'll pick one of your clerks. That one's a judge right now. They'd make an excellent Supreme Court justice. And so it really is, when I say it's a hereditary peerage, I kind of mean it. These justices, in a way, are picking their replacements from the clerks of theirs that have gone on to become judges at the circuit courts. No. We do not want every seat on the Supreme Court to become stagnant by methodology and ideology. The Supreme Court had 8 Republican appointees as recently as 1994. It had all 9 Democratic appointees after FDR left office, and yet we didn't feel like it was ideologically stagnant. You talked about Justices Sotomayor and Kagan and when they were nominated by President Obama. Well, they both replaced Republican appointees on the court because it wasn't unusual for a Republican appointee to be liberal, for a Democratic appointee to maybe be more conservative, for them to retire under different presidents. But when we have this peerage, for lack of a better term, we hurt the court's legitimacy as an institution.
And we're talking with Sarah Isgur, editor of the SCOTUSblog and author of this book, Last Branch Standing, a potentially surprising, occasionally witty journey inside today's Supreme Court. And next week on the Q&A podcast, it's part 2 of our conversation with Sarah Isgur, author of Last Branch Standing.